How do I find the right lawyer? In this video series, I will answer this question by answering 7 constituent questions.
This is Christian attorney R.L. Johnson, lawfullife.us. The purpose of this channel is to make the law accessible to real people. So if you find the information in this video helpful, please subscribe and share it with other individuals. Also, I want to thank everyone who has subscribed to the channel thus far. Please feel free to send me questions or make suggestions about other videos that you'd like to see us do. Now on to the topic of this video. How do I select the right lawyer for me? So with the model rules as an indispensable backdrop, you have to strive first to secure an attorney who believes in you and earnestly cares about your dilemma. Now, for many persons in the market to hire an attorney, price is towards the top of their list, if not at the top of their list, but it really shouldn't be. Rather, what I suggest is people turn to my 4 criteria for selecting an attorney. And the 4 criteria that I want to impose on top of the presumption that the attorney is going to act ethically in accordance with the rules are wisdom, empathy, commitment, and competence. So I'll cover each of these principles one at a time, and where applicable, I will mention where the model rules intersect with these 4 principles. Now, the first of the 4 principles is wisdom. The model rule says absolutely nothing about wisdom, but obviously you don't want to entrust your life, custody of your children, business, or property to someone who is unwise. It is written that a fool gives full vent to his spirit, but a wise man quietly holds back. And to me, in the legal domain, what this means is that you want someone who is going to take into consideration not only your rights and the risk that might befall you, but also the feelings and the impact of your actions on others. And the best and most common example of this that I can think of occurs in dependency proceedings. And that is proceedings where the parents are in a dispute concerning the custody, parenting time, or the cost of care of a child. Now, it goes without saying, when a mom and dad are engaged in a dispute concerning a child or children, whatever objects that bound those 2 people together have probably been destroyed and cannot be repaired. And as a result, they've turned to a third party, either a judge, a mediator, or a magistrate, to decide what's in the best interest of that child or those children. And it should also go without saying that once people have entered that arena with the objects of matrimony or affection having been destroyed, they enter that arena in a state of war. The problem with that is that when parents go to war, oftentimes the children become the ammunition. A wise attorney is going to counsel people as to the risks foreseeable in these type of proceedings and the temptation to use the children as ammunition against their opponent. Now, most clients, upon being counseled or advised as to the risks associated with these proceedings, will invariably extol that they would never allow their child to become ammunition in their battle with their spouse or ex-significant other. But in the heat of battle, oftentimes, it becomes difficult for people to resist the temptation and maintain their objectivity. And wise counsel will certainly advise a person when they've strayed off of the reservation and are now engaged in some type of vexatious endeavor against the other. So in short, you want an attorney who is going to be considerate of others as well as you, and the long-term impact your actions, if left unmoored from what's right and what's wrong, could take the case. Second in my 4 criteria is empathy. Empathy is a term that's used to describe a wide range of experiences. However, researchers generally define the term empathy as the ability to sense other people's emotions, coupled with the ability to imagine what someone else might be thinking or feeling. However, the Apostle Peter counseled us that Christians have to have compassion for one another, love one another as brothers, be tender-hearted and courteous. Additionally, the Apostle Paul encouraged empathy when he told us that Christians are to rejoice with those who rejoice and mourn with those who mourn. Consequently, an empathetic attorney is not only going to listen to your concerns in such a way that they can reflect back both the content and the perception of what you're saying, but they're going to quickly discern how to tie what your ultimate goals are in your litigation in such a way that he or she is striving to do what's achievable, and at the end of all of that, help you find peace. Third on my list is commitment. An attorney who's committed to your case is going to dedicate him or herself to your cause. Now, Model Rule 1.3 talks about diligence and acting responsibly and promptly in representing a client. And Model Rule 1.3 sets forth 5 specific tests, if you will, for reasonable diligence and promptness. First, a lawyer who pursues a matter on behalf of a client is going to do so despite obstruction opposition, or personal inconvenience. He or she will take whatever lawful and ethical measures are available to him or her to vindicate the client's endeavor. Now, as I've indicated earlier when in talking about wisdom, the use of offensive tactics that preclude the treating of all persons involved in the legal process with courtesy and respect are expressly prohibited by the rules. So if your idea of an attorney is a bulldog who's going to go into court and treat everything like the much coveted bone, you have to remember that a bulldog is mostly muscle and teeth. And you don't want someone who's going to enter into an endeavor in your name, treating people with disrespect and discourtesy. And as a matter of fact, such conduct is categorically frowned upon by most judges as a violation of the local rules of civility. Indeed, it is written that we should walk in wisdom towards outsiders, making the best use of time, and letting our conversations always be full of grace and seasoned with salt, so that we may best know how to answer everyone. The second test, if you will, in Rule 1.3 is that a lawyer you hire should not undertake your endeavor unless he or she has sufficient time to give your case the attention it deserves. Third, lawyers are not to procrastinate. Many cases are lost easily because someone misses a deadline or fails to file a document on time. Indeed, a highly grieved area of law is lawyers who miss deadlines because they probably have more cases than they can handle, and as a result, fail to build in the necessary redundancy in their scheduling and in-office practices to prevent missing deadlines or required filings. That said, there's absolutely nothing wrong. In fact, the rules expressly provide that if an extension or a postponement is requested by your opponent and it's reasonable to do so because it will not prejudice your client, lawyers are expected to be civil and grant such extensions or postponements. And as a matter of fact, you most certainly want to be courteous to the other side because the time may arise when you need that same courtesy extended to you. So willingness to grant an extension or a postponement when it does not prejudice your client is not procrastination, it's simply being civil. The fourth test was that the attorney has to carry out the case to its conclusion. If you hire a lawyer, that lawyer has to follow through with that case until either you discharge that lawyer, the matter is resolved and closed by the court, or the lawyer seeks leave from the court to be withdrawn from your case. And when that occurs, the court will generally not allow the lawyer to withdraw unless you're given adequate time to find substitute counsel. So when a lawyer undertakes your endeavor, he or she is signing on for the long haul. And that's the case regardless of whether or not your fee has been paid in full, because even if your fee has not been paid in full and you're engaged in something in a courtroom, that lawyer cannot simply abandon you in court without permission of the judge. Closely connected to that is the rule regarding sole practitioners governed under 1.3, and that is that when a sole practitioner undertakes your case, he or she has to build in a plan for another lawyer to pick up the reins and assist you with in terms of communication as to what happened to the lawyer and where your case is, so that you can act promptly and responsibly in finding substitute counsel. So even if the lawyer becomes disabled or is unable to continue the representation, there's a requirement that the lawyer make provisions if he or she is practicing solo to safeguard your interests. Closely connected to Rule 1.3 governing reasonable diligence and promptness is Rule 1.4, which governs a lawyer's communication with his or her client. Rule 1.4 requires lawyers to communicate with their clients promptly and inform the client of any decision or circumstance which requires your informed consent. For example, any type of settlement negotiations or any settlement that might be proffered by the other side, a lawyer cannot accept or reject an offer from the other side without your informed consent. And as a matter of fact, I'd go as far as to say without your written consent. Secondly, lawyers are required to reasonably consult with clients about the means by which the client's objectives are to be accomplished. So while sometimes it might be getting inside baseball or getting into the weeds to explain how a lawyer plans to achieve one of your objectives, he or she is required to consult with you within reason as to how, which is to say, what legal mechanisms is he or she going to use to help you achieve your goals. Rule 1.4 also requires lawyers to keep you reasonably informed about the status of your case. This includes deadlines for filing. This includes rulings that may have been against you in a particular matter. And by that I mean there are many things that happen in court for which the client need not appear. Now, you most certainly have the right to appear, and you probably should be available for all proceedings involving your case, but there are many things that happen in court where the client's presence is not required. Rule 1.4 requires attorneys to keep you advised of everything that's happening in your case that affects you or your rights. And this includes hearings that you may not have attended, either because you were not aware of them or because you were not required to be there. Lawyers are required to promptly comply with any reasonable request you might make for information. This is closely connected to the previous requirement to keep the client reasonably informed about the status of the matter. And fifth, Rule 1.4 requires the attorney to consult with the client as to the limitations placed on a lawyer's conduct by either the rules of professional conduct, the law, or perhaps by local rule. So in addition to the rules of professional conduct, the rules governing civil procedure, the rules governing criminal procedure, and sometimes local rules that may apply to a particular jurisdiction, judges in individual courtrooms sometimes have their own procedural rules and expectations of lawyers practicing in their courtroom. If you established a goal or you've articulated a goal with an attorney as to things that you want done or objectives you want to achieve, and even though you and your attorney may have outlined a plan for achieving those objectives or those goals, if the lawyer becomes aware of a restriction or limitation placed on his or her conduct as a result of one of the rules I mentioned above, that lawyer is required to let you know about those relevant limitations. I think it's also important to note that many times lawyers do not openly tell clients about the limitations of their case. This is a great shortcoming of many lawyers, and it's also a great disservice to the client. You need to know going in what the weaknesses of your case happen to be. There's no such thing as a slam dunk going to court. I don't care how clearly it appears that the law is on your side. There's always a way around an objective you may have. I tell clients all the time, don't underestimate the power of a good story. So while the law may be on your side, the other side may appear in court with a stunning and amazing and/or compelling story that causes the judge to want to make an exception or to challenge or encourage you to pursue other ways of achieving your objectives, like mediation, for example. And lawyers who are seasoned in their particular area of practice and know the various predilections of any individual judge can certainly tell you, having listened empathetically to your case, as to any shortcomings or flaws in your case, and they most certainly have a duty to do so. And I go as far as to say, if they don't tell you about the potential limitations in your case, you need to ask about that. Well, that's it for this video. If you find this video helpful in any way, please share it with others. Also, consider subscribing to the channel so that you can be notified when we produce new videos. As I've indicated before, the purpose of this channel is to make the law accessible to real people and not just the exclusive province of attorneys.
Thank you for watching. We profess the truth that we can do nothing without God. God bless.